And I'm going to very quickly go through this very simple tutorial that you should see on the screen, just to make sure that everybody knows if they have issues, how to problem solve. So basically, usually the problem is that you can't hear the webinar. So check your audio. And the way you'll do that is down in the lower right-hand corner, you see the icon with the speakers on it. You'll all be muted on the microphone, but on the speakers, you want to click that icon and make sure that it is unmuted, that this box is unchecked, and that your volume is turned up right here. So again, the volume up, the mute button is unchecked. And you can also check on the audio panel and make sure that your speakers there are unmuted. If this does not work, here's the play sound just to double check that you are unmuted. And if this doesn't work, we suggest that you restart your computer and re-sign into the webinar. Your microphone is muted, but you will have a chance on the chat section to post questions. The chat is right over here on the questions button. So again, over on your dashboard, you will see this and can post your questions there. Since we'll have a small audience, Karen will be able to view those, and if we don't get to that, I'll hold our attention as we end this. Okay, I am going to now turn the presentation over to Karen, and again, we welcome you and thanks for coming. We'll be going till about 11:30. Thank you.
Well, thanks, Gail, and thanks for setting this up. I just want you all to know that one of the big areas of my practice in Nebraska is representing what we call in Nebraska educational service units, what you guys call regions in Texas. And I'm just such a huge believer in the work that we can do when we aggregate educational resources through a regional intermediate service agency like your educational regions. So I'm really glad to be able to support the work that Region 10 is doing, and delighted to have a chance to talk to you all. The other reason I'm excited about this is because I don't always get a chance to drill down to building level or classroom level staff, and you guys are the ones that are actually doing the heavy lifting on these issues like identifying assistive technology and IEPs. So I really want this to be useful to you as case managers or classroom teachers or special ed directors. And I'd much rather, deal with the issues that you guys are dealing with rather than just march through stuff and not ever have a chance for you to ask questions. So I'll tell you when we get to kind of the organizational slide, I've got 2 different spots during the presentation where I'm going to stop and check in and see if anybody's typed in a question. And then I'll also try to leave some time at the end. The way Gail has this set up, this technology, I think is going to be really cool. You should be able to plop your question into that comment box as we go along, and then when we get to the spot where I'm going to answer questions, I will jump out of my slides and open that comment box back up and answer the questions that have come in. So as you have questions, you can type them in, and then I'll be able to kind of aggregate them and answer them all together. Okay, so I have a particular interest in assistive technology and in leveraging educational technology in general to better support students. And one of the interesting things in the educational world is to see how education technology really has evolved. This is from an interesting survey in U.S. News & World Report that they sponsored of educators in the classroom. One of the things that we're really seeing as educational technology evolves is we've gone from a medical model where AT was really designed for kids with like profound delays or profound health impairments to a social model. That means the focus is no longer on the technology itself, but on what we want to accomplish with it. It also means that the focus is on the person, what the person wants to do and how they're going to interact with people, not on the individual's impairment. We've seen a real shift from a professional-driven to a consumer-driven kind of approach to AT. I'm sure you guys can all attest to the fact that parents are showing up and asking for an iPad because they've seen them advertised on an Apple commercial. That consumer-driven model has benefits to it, but it also has some big implications for educational contexts. Universal design, which I'm sure you guys are sick of hearing about, but it really has implications here as well. Universal design means we have multiple means of acquiring information for our students. We also have multiple ways of tapping into how kids learn and what their interests are, what their motivators are. There's some really interesting research being done on how much more engaged gen ed students are in the classroom when they have access to social media. And if we're going to use social media to leverage engagement for gen ed, we're going to have to make sure that we have the ability for special ed kids to have those same engagement opportunities. We are seeing a huge increase now in professional development for staff members that are using AT and qualifications for AT providers. One of the big frustrations for all of us nationwide is that there aren't right now universal standards. In Texas, I know you guys have done a lot to develop some rubrics and have some criterion for AT evaluations and providers, but those aren't standardized or even common across the country. And then, of course, now we've got flipping. We've got one-to-one initiatives where every kid in the school district has a laptop or a Chromebook or an iPad. We also have schools that are implementing bring your own device, where everyone is assumed to have either a phone or a laptop in the classroom, even if the school didn't provide it. And again, that has significant implications, as we'll see, for assistive technology in a special education context. We've also had a change in how we're having kids access education. Back in 1985, when 1975, when the Education for Handicapped Children Act was passed, the focus was on access to schools. Can kids in a wheelchair actually get into the building? Then in 1990, we passed IDEA on a national level, and that really gave kids access to the classroom. So you're not just in the building warehoused in a resource room. There's this mainstreaming component where we want students to be with typically developing peers in the classroom as often as possible if it's appropriate. Then in 1997, the revisions to IDEA really focused on having kids access the general curriculum despite their disability, again, if it was appropriate. And so we had a big focus on making educational pieces available. And then in the most recent revisions to IDEA in 2004, we saw this shift to access to instructional materials. In this version of IDEA, states are given the obligation to make sure that textbooks are accessible to students with disabilities, and schools are given a mandate to have assistive technology available to students. So you can see that we're evolving between to have a deeper or more rich and complete understanding of what it really means for students with disabilities to have educational access. And what we're doing with AT is part and parcel of that. Okay, so here's what I want to do with you all for the next hour and 20 minutes. We will stop at 11:30. I want to be respectful of your time. So the first about 30 minutes, it's going to be probably 20 minutes and change. I want to talk about the interaction between the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and the Individuals with Disabilities in Education Act. Those three acts all work together to impose separate obligations on schools, and in the AT universe, you really need to be conversant with the requirements from all three of those statutes. Then the next big chunk of what we're going to talk about is all IDEA-focused AT, so we're going to do ADA and 504 in the beginning and then kind of let that fall by the wayside. We'll spend the next 20 minutes and change of the session talking about assessment and devices at home. I'll take a break for questions after we do the ADA, 504, and IDEA section. Then I'll take another break for questions after devices at home. We'll do that in the next, like the second chunk of our hour and 30 minutes together. And then the third thing I want to talk about is implementation issues and what do we do when students with disabilities misuse their technology. That'll be the third chunk, and I'll try to leave 5 or 10 minutes at the end, probably closer to 5 minutes at the end for questions about that section of the presentation. Oh, one other thing. When I'm a recovering teacher. I used to teach and then I went to law school. One of the things that I always struggled with was to leave appropriate think time and wait time for my kids to process. You probably have already figured out that I tend to go fast. I will work hard to take pauses and allow for think time and wait time. Sometimes that weirds people out on these webinars because all of a sudden there's just a pause. So if there's a weird pause and you're wondering what's Karen thinking, probably Karen thought, oh shoot, I haven't given them think time or wait time, so I got to stop talking. And so I'll try to allow for that processing time as we go along. Like that. Okay. So first section of stuff that I want to talk about is the combination of the Americans with Disabilities Act, 504 of the Rehabilitation Act, and the Individuals with Disabilities in Education Act. I love this cartoon because I have a fitness watch that tells me to stand up all the time, and I constantly mute it because I don't have time, and so then I feel bad about myself. Okay, schools really have 3 different federal laws that can create obligations for them to provide assistive technology to students and, in some instances, to patrons or parents. And those 3 statutes are the ADA, Section 504, and IDEA. I'm going to talk about these by first talking about IDEA because that's the stuff that you guys all know. Now, you all know that under the IDEA, we are required to provide students with disabilities with a free, appropriate public education. And that means that you have to provide either some meaningful benefit, or some benefit, or meaningful education benefit. And I just didn't look up the Fifth Circuit standard. I should have. But we know that we have to provide students with education benefit, either some or meaningful. Under IDEA, we're not comparing what we do for students with disabilities to what we do for students without disabilities or to what we do to students for other disabilities. The whole focus on the IDEA is on the student, him or herself. That's the I in IEP, right? You've heard that before. We also are not allowed, if a student needs a service to receive FAPE, we're not allowed to complain as a school that that's going to cost too much or that fundamentally alters our program. Those are not defenses to our obligation to provide FAPE. You'll see that that's different when we get to looking at the other laws. So IDEA requires school districts, public agencies, to assure that assistive technology is available to students if the child with a disability requires it, either for special ed or for related services or as part of their supplementary aids and services. So basically, if the child needs it for FAPE, or to access educational benefit, then we are obligated to provide that assistive technology. Doesn't matter how much it costs, doesn't matter if it modifies our program. IDEA 2004 really has an emphasis on assistive technology. Congress was really convinced, or the people that drafted the legislation at least, were really convinced that AT was a way to support and increase educational achievement of students with disabilities. You are required at every IEP meeting to at least consider assistive technology, and I don't know what you guys do in Region 10. A lot of regions have like some sort of online system that has your IEP forms on there, and there's usually a little box to check where you're talking about assistive technology. Now, responsibility for deciding whether or not a student needs AT still falls on the IEP team. And we are obligated to provide instructional materials in a format that's accessible to the student no matter what their communication mode is. Now, all of that is what you know about IDEA. Compare those obligations for assistive technology from IDEA with the obligations that exist in Section 504 of the Rehabilitation Act. Remember, 504 is designed to meet the needs of disabled students so that they can adequately access opportunities equally to those of non-disabled students. So Section 504 begins a comparative standard. If the student who doesn't have a mobility impairment can walk up the steps, we have to give a student in a wheelchair the ability to somehow get into the building too. That's a comparative standard. And really, Section 504 is all about access, having the ability to access educational opportunities. So here's the language that really matters for assistive technology in Section 504. It says that no otherwise qualified individual with a disability shall, just because of his or her disability, be excluded from participation in, denied the benefits of, or be subjected to discrimination under any federally funded program. There's no explicit reference to assistive technology in here, but you can see that it's kind of embedded in that equality of access language. Assistive technology would be necessary if you need to have it for a related service for a student with a 504 plan or an IEP. Sometimes we have students that don't have significant enough impairments like ADHD. They don't meet the qualifiers for an IEP, but the student still needs a 504 plan, and you're required then to talk about whether or not that 504 plan should include an assistive technology element, like a recording device. 504 also requires assistive technology accommodations for non-students. 504 applies to patrons, to parents, to anybody that would be accessing the benefits of your programming. There are cases where schools have been obligated under Section 504 to provide a sign language interpreter to interpret board meetings. There's a case where a school was required to have CART, live transcribing of what was happening for a hearing impaired parent at a graduation ceremony. And a lot of times we have co-occurrence of parents with disabilities and students with disabilities. So I really like my special ed staff to be aware that our AT accommodation obligation under Section 504 might run to other people other than just students. Okay, so our obligations could be found in IDEA. They could be found in Section 504. They could also be found in Title II of the Americans with Disabilities Act. Now, IDEA says students get a free, appropriate public education. 504 says disabled students have equality of access. The Americans with Disabilities Act says people with disabilities have to have equal opportunity to benefit from or participate in the activities of any public entity. It requires the public entity also to give primary consideration to the method of accommodation that's requested by the family. That's different than IDEA, where really the method of accommodation is driven by the student's educational needs. Under the ADA, you're supposed to give primary consideration to the family's request. They still don't have the controlling vote, but they have much, much more influence over the decision making under ADA analysis. So here's the necessary language, or the relevant language from the ADA. It says that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in, be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination. This next bullet point is huge, and it's been an underappreciated element of our obligations for assistive technology. It says that a public entity shall take appropriate steps to ensure that communications with applicants, participants, members of the public, and companions are as effective as communications with others. That last phrase, as effective as communications with others, you can see that that's just completely different than IDEA. This is an inherently comparative standard. It's not whether or not what the child is getting is enough for them to receive some education benefit. It's whether or not the communication the child is receiving is as effective as communications with others. And that's just a completely different standard that we need to emphasize in our in special ed. Under ADA, they have a whole list of the auxiliary aids and services that a public entity might be required to provide. These first few bullet points aren't going to be too surprising to people that are used to our obligations under special ed. If you're talking to a superintendent about providing this sort of stuff to a parent that's coming to a board meeting to yell at the board about their tax levy, your superintendent gets kind of irritated that we have to provide these kind of services to people that aren't even necessarily students. So let me give you this case to show you an example of what I'm talking about in terms of providing services to a non-student. This Talbot County case comes from Pennsylvania. It's an OCR complaint from 2005, and it was a parent that was significantly hearing impaired. This parent asked the district to bring in the live transcribing services, CART services, during IEP meetings because the parent wanted to see everything that was being said during the IEP. The special ed director said, no, we don't want to pay for CART services. Instead, what we're going to do is we're going to have our staff provide other accommodations. We're going to have you speak slowly. We're going to have you turn towards the parent when you're making comments. And what happened in the heat of the IEP meeting, and this is probably no surprise to you all, is that sometimes the accommodations weren't used. There was cross-talking, staff didn't always remember to turn toward the parent. And so the parent said this wasn't as good, and the special ed director says, well, it was good enough, right? And the special ed director here, you can tell that he or she had been trained up in the Rowley standard, knowing that you don't have to provide perfection. You don't have to, that's the line that we all use. You don't have to provide a Cadillac. You just have to provide a Ford. That's the Rowley standard, right? It doesn't have to be as good as some other outside standard. It just has to be good enough. But here the court said your obligations to the parent don't come from the IDEA, or the OCR found, not the court. Your obligations to the parent come from Section 504 and the Americans with Disabilities Act. And those two laws have a comparative standard. You have to show that the communication you were giving the parent was as effective as the communication that a hearing parent would have received. And here, once the parent said there was stuff that happened that I would have gotten from CART that I didn't get from the other accommodations, pretty much the jig was up for the school, and OCR found violations. The parent was unable to participate in the meeting effectively. Now, OCR said, you as the school district are not required to automatically adopt the parent's preferred methodology, but you're under an obligation to provide a means of communication that would be as effective as the means that would be at hand for a parent with hearing. And really in this context is probably going to be CART or perhaps a really good ASL interpreter. We'd have to look at the facts of whether or not this parent uses ASL, but you can see kind of how the Rowley standard does not apply in a parent context. These cases from the Ninth Circuit are probably cases that you guys have heard about. These are students, two students who had significant hearing impairments who requested that the school district provide them with CART services instead of just sign language interpreters. And for years and years, we've all said, and it's true, in an IDEA context, you don't automatically have to have CART services if you have an effective methodology for the student to be able to communicate and receive communication about their education. What these two cases did in the Ninth Circuit is these students challenged the school's denial of their request for CART, not saying that they weren't receiving a free appropriate public education under IDEA, but instead saying that the communication they were getting wasn't as good as the communication that their hearing peers were getting. It's this exact same thing that we just talked about in the parent context, only here the kid picked not the IDEA standard. I want the court to judge me by the ADA standard. So these students requested CART services from the school. The IEP said, no, you don't need that for FAPE. Our ASL services are good enough. And the parents went to due process. The hearing officer and the district court ruled for the school, which is what I think all of us expected, because the student was able to receive a free appropriate public education. And then the hearing officer in the school said, basically, if the school meets their IDEA obligations, they've automatically met their ADA obligations, and we don't have to worry about these two sets of standards. The Ninth Circuit was not down with that. They said that proving that you've complied with your obligation to provide FAPE does not necessarily mean that you've complied with the IDEA or with the ADA. There's a great quote from this court decision. The court said, given the differences between the two statutes, we are unable to articulate any unified theory for how they will interact in particular cases. So I can't give you a bullet point list of slides that say, you know, if you do this and do that, then you'll always meet both IDEA and ADA. And I think the Ninth Circuit is being honest when they say we can't tell you how these two competing elements of obligation of communication services are going to work in any particular circumstance. Later, the court says Title II imposes obligations for effective communication upon public schools independent of, not coextensive with, the school's obligation under IDEA. So you've got two sets of obligations to students with communication impairments. One comes from IDEA, which is the stuff that you're probably all real familiar with, and the other comes from your obligations under Title II, and they aren't, they sometimes match up and they sometimes don't. This is a quote that I thought was worth putting it out on the slide. IDEA and Title II differ in both ends and means. Substantively, the IDEA sets only a floor of access for education, but requires the school district to provide everything necessary to get the kid to that floor. I think that makes sense. But look at the next sentence. Title II and its implementing regulations taken together require public entities to take steps towards making existing services not just accessible, but equally accessible, right? But that's the bitter of Title II, but the sweet is you only have to do it insofar as doing so doesn't impose an undue burden. So IDEA has a lower standard, but you can't use cost as a defense. ADA and Title II have a higher standard, but you can use cost and alteration as a defense. And those two things are just distinct in both ends and means, which so I like this quote. I think it kind of sets this dual standard up very nicely. So the dear colleague, in this case then the Ninth Circuit held that the school was obligated to provide CART services to both of these students. The students both testified that using ASL left them exhausted at the end of the day or drained, and so the court said ASL was not as effective as CART, and so school was ordered to provide CART. The Office for Civil Rights and the Department of Justice then took this tough decision and used it as the basis for entering a Dear Colleague letter that they sent out in 2004, which they entitled Frequently Asked Questions on Effective Communication. You can see the long title, but it's basically questions on what you have to do to provide communication to students. NSBA, the School Boards Association nationally, protested this letter. They said, gosh, you're just taking one decision from the 8th Circuit and implying it on the entire country. And OCR said, yeah, we don't care. And they reiterated, to comply with both statutes, schools have to provide additional and different aids and services under IDEA than they may have to provide under the ADA. So we've got these dual obligations working now. This is a more recent case, 2015, from Florida. Student with a hearing impairment. A lot of these effective communication cases are hearing or visual impairment cases. In this case, mom revoked IDEA consent because she didn't like what the school was doing. And so the school then completely withdrew IEP services, and they refused to provide the kiddo with services under Section 504. This comes from that letter to McKeithen that I bet a lot of you have heard about. Years ago, the Office for Civil Rights issued a letter that said, basically, if you've offered a parent IDEA services and they've refused, you've offered the parent everything they would get under Section 504, and so you don't have to offer them a 504 if they've already turned down an IEP. In this case, the court said that there were some issues with the school assuming that effective communication didn't have additional obligations under the ADA. Now, here the school did continue to provide the kiddo with access to his FM transmitter, even though we didn't have a 504 plan or an IEP, and that kind of saved the school because the school was able to prove that the student was able to get effective communication even without the 504 or the IEP. But I do want to warn you, I have this case in here to draw your attention to the fact that it's going to be dangerous to rely on that letter to McKeithen that says if the parent says no to an IEP, you don't have to offer a 504 plan. If the accommodations are meaningful communication, I think you would be better served to offer a 504 for that parent so that we can get some effective communication devices going and have them documented. This is a case where a student with a hearing impairment in middle school wanted to call home. And in order to call home, he had to go to the office and have the secretary dial the phone, and then he had to have a conversation with mom on the phone with the office lady standing right there. Mom had a problem with that because she wanted the student's communications to be private. She offered to provide the school district with a closed captioned telephone. That didn't work for the school because they would have had to run additional wires, and it just wasn't going to work from a pragmatic standpoint. And the problem was when mom filed her OCR complaint, the special ed director said, well, I don't know what a non-hearing impaired student would do. Most of our non-hearing impaired students just use their cell phone. And so the school sort of conceded that other students had the ability to talk to their parents in privacy, and this kiddo didn't have the ability to talk to his mom in private. The school defended using a Rowley standard. They said a closed caption phone isn't required for FAPE, but now that you guys are in on the secret of these dual obligations, you know that that's not good enough. When mom filed her complaint with OCR, OCR said that this was a violation and the school entered into a resolution agreement. You can see the quote here that OCR says, providing the ability to call home in a method that wasn't as private as the ability to call home that other kids had, that doesn't provide equal benefit under the ADA Section 504 standard. So that's a key question is, again, that comparative ability. I'm looking at my time, so I'm trying to get through some of these without taking a ton of time, but I think this is a great case. This is a student with a hearing impairment. She had an FM transmitter, but it didn't always work consistently with her hearing aids. And gosh, that's so common with the kids with the hearing aid FM transmitter combo that I work with. It's constantly a battle to get it to work consistently. They had a voice-to-text program, like a Dragon sort of program, but the problem is that didn't really work in the classroom due to the ambient noise. 2 outside experts hired by the school said, really, your best option here is CART services, and the school said, oh my God, no, CART's way too expensive. So the student filed for due process seeking CART services. Now, look at this one. The court said here that denial of CART services wasn't just the denial of the effective communication component of the Americans with Disabilities Act. Here it was actually a denial of FAPE. Why is that? That's because the student was able to prove that the student wasn't able to access the educational programming because of the ineffective supplementary supports and services, and because the experts had recommended CART as necessary for FAPE. Here they're not even talking about Title II, and so the fact that the school said it was going to be way too expensive isn't relevant, right? Because if you're talking about something that's required for FAPE, cost is not a defense. So these dual obligations are kind of huge for schools to think about. So here are my suggestions for best practices here. I think your district really should think about what your practice is about Title II versus IDEA. My preference is still to have your IEP team making these decisions, but that means you're going to have to train your team on these dual competing obligations. You're supposed to give the disabled person's preference. I'm involved in a case right now where the student is a kindergartner who doesn't really know sign language, but mom is adamant that she get sign language, and the case law on that point is that we have to give deference to the family. So if the student is too young to have a preference, we have to give deference to the family. And these are complicated legal issues. This is a time where if your school district will let you, I think it's really smart to contact your attorney. Okay, I'm going to turn to this cartoon. And while you guys are laughing hysterically at that, I'm going to see if we have any questions. I have pulled open my panel here that shows chat questions, and I'm not seeing any questions that anybody has had yet. If you do have questions and you want to start typing, I can see if you start typing, and I'll give you a minute. Awesome. So that means that I have so clearly and completely explained these competing standards that you have complete understanding. No, I totally understand that sometimes you're just processing it all and there's no time to type a question. So I'm going to give a couple more seconds if there is a question, and if there aren't, I'm going to move on and start talking about assistive technology in an IEP context. Okay, I'm going to close this and move on to the next slides. So now that we're going to sort of set 504 and the ADA aside, and now we're going to really dig into our obligations on our best practices for assistive technology that's provided pursuant to a student's IEP. And really there's 4 different and discrete areas in this process that I want you guys to be aware of when you're dealing with these issues. First deals with the initial assessment of what the student's assistive technology needs might be. Secondly, we're going to talk about the student taking the device at home and using it. Thirdly, I know that we like to pretend like teachers always implement everything that we draft into the IEP with fidelity, but they don't. And so we'll talk about some implementation issues. And then the last one is really fascinating to me because kids with disabilities are just like kids without disabilities in that they tend to misuse their technology, and we'll talk about some of the cases involving kiddos with disabilities who have misused the technology that the team has given them as necessary for them to receive educational benefit. So first off, initial assessment of assistive technology needs. Okay, I'm going to assume you all read the cartoon and that you're snickering hysterically. So for your initial assessment, the ADA tells us that there's an incredibly broad definition of what is an assistive technology device. The statute or the regulations define AT as any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified, or customized, that is used to increase, maintain, or improve the functional capabilities of a child with a disability. It doesn't include medical devices like cochlear implants, but it pretty much includes, from soup to nuts, any other gizmo that might help a kid. This includes low-tech technologies like pencil grips, so don't be fooled into thinking that it has to have a battery for it to qualify as assistive technology. It includes the high-tech stuff like Dynavoxes for kids that can't speak, and it also applies to consumer items like iPads and iPods and computer hardware. This is the list in the regulation of what the term includes, and you can see in this bulleted point list that it includes a lot: evaluation, purchasing, selecting, da-da-da. I want you to take a minute and pay particular attention to the last bullet point here. Assistive technology includes training and technical assistance for the kiddo, and this is where I think we sometimes miss the boat, and training and assistance for the child's family. So if we have a child who is going to use, a child with autism that's going to use an iPad in order to engage in some kind of self-calming strategies, we're not only going to have to train the student on how to use that iPad, but we may need to train the parent, and that's especially true if we're going to send the iPad home with the kid, either in terms of social, emotional support, or in terms to use the iPad for educational purposes, academic purposes, but then we have the self-calming software on there as well. So you got to remember that you may have to train the family as well. This is the definition, just continuing on. Any service that assists, da-da-da-da, and these things at the bottom here are 2 more bullet points from that list that was on the prior slide. It includes training or technical assistance for the teachers and staff that are working with the student. It includes employees, it includes the employer, so that training piece is a major part of what would be considered an assistive technology service. This also tells us that when we review the IEP, we have to consider assistive technology as a special factor. Again, I don't know if you guys have that built into your digital form for IEPs, but if you don't, you're going to have to remember to cue the team to discuss it. And the other thing that I worry about is when we have those forms with assistive technology in it, and I'll show you a couple of cases, I don't like it when the team either checks the box and says, yes, he needs assistive technology, and then never says what it is, or says student does not need assistive technology, and then later on in the IEP we talk about the kid using an iPod. So the box checking should be consistent with what the services later on that appear in the plan look like. The things that trigger a formal AT evaluation aren't entirely like, it's not like a checklist like we have RTI for kids that are struggling with reading and math. A formal AT evaluation is not necessary for all students with a disability, even though you have to consider whether the child needs AT for all kids with a disability. If the student's making progress, if the team knows that they can implement particular technology without a formal evaluation like an iPad, or if the kiddo already has access to technology, perhaps through a school district one-to-one program, you wouldn't have to do a formal assistive technology evaluation. I do think the team should consider having a formal AT evaluation done if the student already clearly has needs, especially in the area of communication, or if we're seeing the kids struggle. The second bullet point is important. Parents and advocates have gone to workshops and seminars like this one, and so they've been told that they need to ask for assistive technology evaluations, but remember that they don't get, it's driven by what the student needs, not by what the parent requests. Okay, Greater Albany Public School District is a case from 1999. I draw your attention to that date because this is before the 2004 amendments to IDEA. All of the analysis in this decision from the Oregon State Department of Education is consistent with what happened with the amendments, but I do just want to draw your attention to that. This is a kiddo who had ADHD, and her IEP, her ADHD was bad enough that she had a full-blown IEP, not a 504 plan. And the IEP said she would be allowed to tape record her classes. The IEP team the next school year decided that the recording wasn't necessary. She very rarely did it to begin with, and when she did do it, she didn't particularly make use of it. I mean, she'd record it and then never listen to it. So the team said this recording is not necessary. The parents sued or filed a complaint with the State Department of Ed, and they requested a formal assistive technology evaluation. Their argument was the school should not be allowed to discontinue the provision of assistive technology without some kind of formalized evaluation telling us that the student doesn't need it. The state hearing officer here said the student was making average grades, she was making progress and performing satisfactorily in the general curriculum. There was really no evidence that the IEP team hadn't considered all of that evidence. The team determination was credible, and the hearing officer said this team's decision controls. Now notice, and this will be contrasted with some of our implementation cases later, this is a case where the IEP team itself talked about whether the girl needed the recording. All the way through the first school year, they let the girl continue to tape record the classes when she thought of it, even though I suspect teachers figured out pretty quickly that this wasn't really an accommodation that the student needed or was even making use of when she had it. But they just didn't pull the tape recording mid-school year. They actually had the IEP team make the decision, and that's why this school won this case, because it was a methodology decision by the team, not an implementation teacher by an individual teacher. This District of Columbia case is from 2015, and this is one of those cases where the kid transfers in and their IEP isn't what you want it to be as the district that's receiving the student with the IEP. So the kiddo's original IEP didn't include anything about assistive technology. When the team met to set up the IEP for the District of Columbia school that the kid was moving into, the occupational therapist said that this student didn't like writing, handwriting, physically writing was difficult for the kid, and OT said the kid could benefit from a laptop, but not that they needed it, not that he needed it to receive educational benefit. The team said instead we're going to have the kid use a calculator and then a simple word processor, which was a cheaper technology than a full-blown laptop, and the parents weren't happy. They sued, claiming that the school had failed to conduct a formal assistive technology evaluation, and so the team's decision to only provide a calculator and a word processor shouldn't be given any credence because they didn't have a formalized AT evaluation done. Hearing officer said, nope, nothing in this record indicates that the student needs a formal assistive technology evaluation. The team here considered the technologies that would benefit the kid that were necessary for him to receive a FAPE, and they provided it to him. And this is crucial, this kid was making progress with the supports that were provided. And so because of that, the school district lost, or won, this issue. Now, just to be fair, I want you to know that's why that asterisk is there. The school district ultimately lost this case on other grounds, procedural grounds, but the AT piece of it, the school district won because they had considered and implemented technologies that, although not as expensive and comprehensive as what the OT said would be beneficial, they were sufficient to let the kid make progress. So, and that's using that Rowley standard. This Adrien case is a case from Michigan, due process case. This IEP called for the student to use assistive technology in note-taking and organization. Now, what was interesting was the parent sued here because the school said, the parent said, this is mumbo-jumbo in the IEP unless we've had somebody with letters behind their name do a formal assistive technology evaluation. These accommodations are meaningless, right? And the hearing officer in this case said the lack of a formalized and standardized process for evaluating a student's assistive technology needs, that's not fatal to a school district's ability to be successful in a IEP context. The parent also alleged that the kid had not received any training on note-taking with the iPad. What's interesting is all the kids in this school were given access to the iPad, and all of the kids in the school were given training. Now, the parent argued that this was, since everybody got it, it wasn't special, right? It didn't qualify as special ed, and the hearing officer said that's not true. Just because everybody gets it doesn't mean that that isn't sufficient to benefit this kid and to qualify as the services promised him in his IEP. And so, I mean, the hearing officer says just because it's provided to everyone doesn't mean it's not enough for this student. All students had access to the iPads. There was no need for additional training. Now, this case really brings to mind a situation I was involved in, and I work with, Nebraska is a small state, so we have the same attorneys that we work in opposition to all the time. And the nice thing about that is we kind of get good relationships going with them. But I can always tell when those advocacy lawyers have done a webinar or gone to a conference, because they come back and they've got a whole new list of things that they're going to ask for. And I had opposing counsel in a case come back from a webinar, and he just started demanding all these, well, have you talked about this or that or that? And I didn't even know the things he was asking for I'd never heard of, so I asked him for a list and provided it to the school. And what it was a list of apps that he'd gone to some conference that said, here's 57 apps that kids with autism might benefit from. And it just really draws to mind that just because it's got a switch doesn't mean it's good for the kid. Just because other kids have it doesn't mean it's not sufficient for the needs of the special ed kid. We got to remember that I in IEP means that it can be provided uniquely, or it could be provided to other students, but we know it meets this kid's individualized needs. This Montana case is kind of a sad case. This is an 18-year-old student who's completely nonverbal. She's got significant impairments, and she doesn't really communicate with any methodology. Her main communication, according to the case, is gestures, body language, and grunts and other vocalizations. So this is a student with some significant impairments. In 2001, now notice, whoops, there's a typo, sorry for the T behind the 16. Notice this is a 2016 case. They'd done the AT evaluation in 2001, right? Well, think about that. In 2010, iPads were invented. So the formal AT evaluation was 10 years before even iPads were implemented. And, this is 6 years after iPads were implemented that they still haven't done anything. They had done things, but they hadn't done a formal AT evaluation. This little girl went to a private therapist and got some OT, PT, and speech services from private therapy, and those folks worked with the student on an iPad, and the school used an iPad because the parents had asked for them to buy an iPad, but the problem was, remember when I talked about the training, the problem was they didn't have any training for the staff on how to use that iPad. When the parents sued, the school said, well, look, the parents didn't request an AT evaluation. They've said what we were doing is fine. And the hearing officer here said, look, you don't have an effective means of this girl to communicate at all. It should be obvious to you that you should be continuing to look for an effective method of communication. That should have triggered a more complete evaluation of this girl's communication needs. And it was especially damaging to the school district that in the hearing the staff reported they didn't have any idea of what to do with the iPad. They didn't know how to work with the girl, the iPad. So the fact that they'd purchased a piece of equipment wasn't sufficient when the staff didn't know how to use it. This Elmers case is a case from Illinois, went all the way up to district court in the federal court system. This is a student who was multiply disabled, ADHD, bipolar. The team said that AT was discussed at team meetings, but not in detail. I suspect that they came to the box checking and kind of said, does he need it? Nope, nope, nope. Okay, let's move on. The case manager here testified that, oh God, I just wanted to slap her when I read this case. She doesn't even know what AT means, right? And just not having that knowledge base is incredibly dangerous for the school district. The court here said this didn't count, right? This brief treatment of assistive technology needs constituted a failure to adequately consider their needs basically at all. And so the school district lost this case. What's interesting here is that this is really a fight about graduation. This is really a parent that was fighting whether or not her kiddo was ready to graduate. But she seized upon the assistive technology problem that the school had with their IEP, and they were able to leverage it into finding of a significant, not just a procedural violation, a substantive violation of the obligation to provide FAPE. So he did get his extra years of educational services. So I think your best practices for at the initial evaluation stage, first of all, is to get staff thinking about what assistive technology really means, that it's super broad, and that they need to consider it. I challenge every one of you to go through any current IEP and not find some assistive technology embedded in that IEP, whether that be access to a laptop or whether you're one-to-one or kids have access to the computer lab. You'll knock me over with a feather if we've got students with disabilities that absolutely aren't accessing any assistive technology at all. And remember, that includes things like the pencil grip or lined paper, you know, all the low-tech stuff applies as well. There really are no federal or even state statutes that address the credentials for who an AT evaluator is. That is both a blessing and a curse. That means a lot of what we do you can count as an assistive technology evaluation, but you don't have standards like you do with a school psych or a speech path. You don't have those national standards that you can fall back on. I really think you need to have a multidisciplinary approach. You need both people that know the student and the technology options within the district. What we find is silos. You've got the tech people in one corner and the special ed people in another corner, and we don't always communicate effectively between them, the two of them. And then you also need somebody who's kind of broad thinking to know about technology options generally, not just what the district is doing right now. The good news is this can be both formal and informal, so if you're having good substantive discussions within the team context, I think you'll be pretty much covered in terms of having discussed what the student needs. Oh, last thing, consider all the kids' environments. What I mean by that is remember that we have obligations to provide meaningful access to non-academic, extracurricular, club kind of things, and so we need to be thinking about the student's ability to communicate and function on a team or in a club in addition to in English class or math class. All right, second thing I want to talk about is writing assistive technology into the IEP. Having worked with a lot of teenagers over the last few years, I find this cartoon to be, you know, sort of funny and ironic all at the same time. Okay, so this case involves a second grader with a visual impairment, kind of similar to my kindergartner with a hearing impairment. The school did do a formal assistive technology evaluation, and they tried her out on this magnification software called Zoom Text, where she could zoom in to read things on the computer. They also used an electronic magnifier called VisioBook. The AT evaluator put this girl on an iPad, but the team didn't adopt the iPad for a bunch of reasons. The consultant said she was okay with the iPad, but she did just as well with the other two cheaper technologies. They were also concerned that the iPad software would hook into the Promethean board that the teacher was using, and that the student would have access to teacher files once they were in through the Promethean board. Now, what's interesting to me here is the consultant also recommended a whole bunch of boring stuff that nobody thought about, like an adaptive keyboard, like having this girl learn how to type earlier than her peers, having her learn keystrokes instead of button commands because pushing the mouse button was difficult for her given her impairment. And those are things that the parents really weren't interested in. What they really wanted was an iPad, right? They wanted a gizmo that was going to help this girl instead of doing the boring hard stuff like learning how to use these technologies. Parents requested then an independent evaluation. If you do a formal AT evaluation, parents are entitled to ask for an independent education evaluation. And really what the parents were after was to give this girl an iPad that would let her connect with the Promethean board in the classroom so that she could see on the iPad what the teacher was putting up on the board. The parents also wanted apps that were specifically designed for students with visual impairments. They thought that that would be better than using apps that could be applied across multiple technologies. The school district here filed for due process rather than grant the IEE. I find schools doing that more and more often, challenging the IEE request by defending their initial evaluation. Hearing officer here said, and I love this quote, "The applicable legal issues in this case do not require me to choose one device over another," right? The hearing officer also said, "I don't have to worry about whether other jurisdictions are using it because a neighboring school was using iPads for kids." The hearing officer said it's not really what other schools are doing. Here the whole question is, was the school's assessment appropriate? And it was, because the evaluator went through, was familiar with the student's needs. Again, the way to win these cases is to provide good services for students. the student was already making progress with the recommended supports, which undermined the parent's argument that she needed the iPad to receive a free, appropriate public education. This Oregon case, 2014, this is one of these kids transferring back and forth cases. I see a lot of these assistive technology disconnects happening when kids jump from district to district, because so much of what we do with technology is kind of tied to our individual district's preferences. The IEP from the kids' charter school, they checked the box that said student needs no assistive technology, which I find so typical. But then, under supplemental aids and services, they said that the student would have access to the iPad/technology for note-taking, for his vocabulary, for language arts supports. This is classic. I bet I see this in a third of the IEPs that I look at, where it says no AT, and then they list the iPad as a supplemental aid. The local district implemented the charter school's IEP. They provided, this kid was allowed to take pictures of notes with his phone and given extended time to submit his work. They let this kid use Evernote on his phone in the classroom, which I think is really great accommodation. I love Evernote as a multi-platform, multi-device platform. They gave this student access to the language arts software in the resource room and in the counseling center, but not in the classroom because they just didn't have that capacity in this building. They offered him a tablet other than an iPad. The parents wanted the iPad, and look, you know, again, it's always idiosyncratic about what technology parents prefer, why. The reason the parents were so adamant that this kid had to have an iPad is because the iPad would sync up to their home computer. They must have been an Apple house instead of a PC house. And so the parents said, some other tablet doesn't work. It's an iPad or nothing. And so they took the family to the school to due process. Hearing officer said, letting the kid use the phone in the classroom served the same purpose as an iPad. Now, I think it's really unwise. This is why I think it's really unwise to put iPad, iPod, or any other branded device into the IEP, saying things like student will be able to use tablet, or student will be able to use mobile technology such as phone or tablet, is way smarter than writing in iPad, because now you've like sort of specified the brand of technology that you're going to provide. Hearing officer here said the district's offer of another type of tablet was sufficient. It was equal to what the kiddo would have had in the IEP. Now look, this is important because otherwise the parents would have won this case. There was no showing that there was an actual educational need to sync with the home computer, but if there had been an educational need to sync with the home computer, then the parents would have been able to claim either that the school would have to provide a computer at home that the tablet would sync with, or provide an iPad that would sync with the existing computer. Even though it did not specifically provide an iPad to the student, the district honored the essence of the previous IEP and the student's potential need for assistive technology. So when you write the IEP, don't write the actual brand name in, but if you have a kid transferring in from another district that's got a technology that you don't use, see if what you're providing is equivalent to what has been written into the IEP that you have to implement until you get your own drafted. DC case 2015, this is a kid with SLD. He's got poor handwriting, he's easily distracted, poor attendance. A lot of what is described about the student's behaviors is just kind of a pain in the butt teenage boy, right? The parents were very upset that the IEP didn't provide the student with enough assistive technology. I've got a screenshot here. This is actually from the case itself. These are my notes. You can see how bad my handwriting is. But I love this. In the case itself, it says, the student uses television and electronics in his room late at night. He has difficulty getting to sleep in the evening and has been diagnosed with behaviorally induced insufficient sleep syndrome, circadian rhythm disorder, and sleep apnea, NOS. What that tells me is the kid is on his phone all night, and that's hurting him educationally, not helping him. And I just found it ironic that, of course, the parent is suing to give us more tech for this kid when tech is hurting this kid. That's all. So the parent requested a formal AT evaluation, school conducted it, and then the evaluator, again, recommended all this boring stuff that the parent really didn't want. Slant board, handouts, word processing software, text-to-speech reader, all this stuff. But look at the second to last thing in the bullet point. Here, voice recorder was something that the AT evaluator suggested. Now, the team felt that most of this stuff was already available to the student, but he didn't use it. So the team only added voice recorder to the student's IEP because that was the only thing that they saw on this list that he didn't already have access to. Now, here's the problem. IEP team met in March. The voice recorder was not provided by the end of the school year. And the parent said that this was a failure to provide the services that had been promised to the student in his IEP. The school said, we ordered it, and I'm assuming they were using some kind of like, e-commerce piece of software that ran through the school district system so they could get it at a bulk rate and not have to pay taxes on it. But that system wasn't very speedy, so it hadn't arrived by the end of the school year. And look at this, the hearing officer said, there's nothing in the record to suggest that the voice recorders are unavailable at retail stores in the District of Columbia. Do not let your school district's procurement system slow you down in providing the services and technologies that you promised a kid. Hearing officer was just gobsmacked that the school couldn't get a voice recorder within a few weeks, really I would say a few days, and that this delay resulted in a denial of FAPE. Now notice, this team really, I think, didn't believe that the kid needed this technology, but they wrote it into the IEP anyway. And in my experience, when the school drags its feet about getting technology ordered or implemented, that means that somebody in the system doesn't really think this is necessary, right? But once you put it into the IEP, it's deemed to be necessary. And then finally, notice here that the team's decision to only provide one thing out of this gigantic list, their selection wasn't criticized. So the decision-making process was good. It was just their failure to actually provide the device that resulted in FAPE. Okay, this case is from Ohio, 2015. It's an IEP that listed several assistive technology elements, an iPad, and it stated that the kid would use, quote, the join.me application to access the smartboard. Now, I've had this happen to my schools. They also said that there was a Google Calendar that was accessible by student and staff. The problem was the app released an update, and after the app was updated, it never worked for this kid again. The iPad and the app and the kid and the school's technology, somewhere in that chain, there was a disconnect, and it just didn't work. So the teacher eventually got frustrated that the Join Me app wasn't working, and so she used a substitute app called Splashtop instead of Join Me, and so that's how she had this student accessing the smartboard. The school asked the parents to come to an IEP meeting to amend the IEP. They refused, and instead they filed a complaint with the State Department of Education alleging that the school had failed to implement the IEP with fidelity as written. This is kind of a crappy outcome. The state found the school to be out of compliance. And I think what the state was doing here was slapping the school not so much for using a substitute app, but for drafting the IEP poorly to begin with. They said this IEP has not been implemented as written. They ordered the school to convene the IEP team to amend the IEP to list the iPad and the accommodations that would be comparable to Join Me instead of saying Join Me itself. So just like the other one where we were talking about iPad versus tablet, I don't want you to ever list a specific program or app that the kid is going to use. I want you to say the functions that the app will serve. So a student will be allowed to use an application to access and mirror what's happening on the smartboard, paren, for example, Join Me, close paren, right? So that we aren't committing ourselves to a particular product. Here the SEA said the team's IEP must describe the function of the application rather than just naming it. I think that's really good advice. And it directed the school to provide the parents with prior written notice to the parents after the IEP meeting. So I think it's kind of crappy that the school got tagged here, but I think their failure was in drafting the IEP, not in implementing it. Okay, so here are my suggested best practices. I think you need to remember the broad definition so you don't avoid those, you don't have those internal inconsistencies. Remember, a product is not a plan, right? Saying iPad is not enough. What is the kid going to do with the iPad? How are we going to support the iPad? I think you need to think about the ability of students to use apps and systems across platforms. That's one of the reasons I love Evernote and other cloud-based softwares, because then it doesn't matter what the product is. It doesn't matter what the technology is. It matters that the kid can access the product. So that could be phone or computer or iPad, and if the kid forgets the iPad at home, we've got another iPad at school that can access the same thing. I think we need to politely refocus parents on what the kid needs. not on what the latest and greatest technology is. And I think don't let your forms drive your process. Don't let the fact that you check the box, that you have to check the box, change the fact that that assistive technology might be listed someplace else. Okay, this last one I think is important. If some parent is talking about a piece of technology or something that the kid needs, and you can tell that your staff is in their heart of hearts rolling their eyes, I would really think long and hard before you write that into the IEP. Because once the staff starts rolling their eyes, that means that they don't believe in it. They don't believe the kid needs it. But once you write it into the IEP, they're going to have to provide it. So if you know the staff thinks it's stupid, to me, that's a sign that the team should circle back and really talk about, is this technology necessary for the kid to receive education benefit, or are we just putting this in here to placate the parents? And I think putting stuff in to placate the parents is really dangerous, because then your staff has a tendency not to want to implement with fidelity. This is the point at which we're going to break for a question, so I'm not going to show you that cartoon yet. Oh, good, we have questions. All right, let me, yes, this webinar is being recorded, and there's how to access it. Okay, now I have a question. Kid has been approved for assistive technology through special ed services. Student was provided with a simple low-tech device like a pencil grip. Not likely parents will be trained. Should we still be offering training? Always offer training. No, I mean, that's a great question, but the question is, does the parent need training in order to effectively use the technology? Now, I'll tell you, my son, when he was born, his feet were turned out. That's very common. And my pediatrician prescribed those shoes that turn the kid's feet back in. So I went and got them and very carefully put them on my kiddo's feet. And I show up at church, and one of the guys that goes to church with me is also a pediatrician, and he's a sweet little old man. And he stopped me and he goes, "Karen, I see that Eli has those shoes. That's very common. But did you know you have them on the wrong feet?" And so what I had done is I'd put the shoes designed to correct his step, I put them in a way that actually made it worse, right? That is an example of low-tech assistive technology that parents might need training on. So if the pencil grip is one that you have to do something funky to get it on the pencil, or if it's not obvious, you would still have to provide that training. But you really would only have to provide training if it's necessary for the parents to understand. This last little phrase there, should we always offer training? I don't think that's a bad idea. If you're talking about low-tech stuff in the IEP, at that meeting, I think it's sensible for the case manager to say to mom and dad, we think you'll know how to operate this. If you need help, let us know. It would be included in our services to you to train you if what you need. Okay, next question. Oh, that's the same question. Okay. So I think that's it for questions. If any of you want to quick type something up, I'll give you a couple seconds. But I'm also looking at my time and want to make sure that I'm faithful to get you done and out of here at 11:30. So the next thing I want to talk about is assistive technology devices at home. Okay, so the IDEA itself says on a case-by-case basis, you have to decide whether or not using school-purchased devices is necessary at home in order for the child to receive FAPE. And so despite the fact that it makes your superintendents and principals crazy sometimes, you do have to consider whether or not you have to send that iPad or pencil grip or whatever home, even though you're worried as a organization that that technology will get lost or damaged at home. If the student's IEP team determines that the kid has to have the AT at home, the school has to provide it at public expense. Notice that this is an IEP team decision, not a school decision or an administrator decision. The typical conflict is that the parent wants an iPad. Usually it's an iPad. It used to be computers, but now it's iPad. So the typical conflict is they want it at home and the team disagrees. But the kid's use of assistive technology at home, I want you to think about the flip side as well. Kiddo using assistive technology at home could trigger your obligation at school to consider whether or not the student needs that AT to make educational progress at school. And that's this, oh no, that's not this case, it's the next case. So this case is an Iowa case where the school had a one-to-one laptop program. Everybody in the school got a laptop. This student had a print disability, and he didn't have the speech-to-text software installed on his laptop. I think it was Dragon, but whatever it was, that software had not been installed on his laptop, so he couldn't talk to his computer and have the words appear out on the screen. The school district ordered the software in the summer, but they didn't install it until 7 full weeks, almost the entire first quarter of the fall term. He didn't have that software. The parents filed a complaint with the State Department of Education. The school district said the student has access to assistive technology on the classroom-based computers. He just doesn't have it on the laptop that he gets to take home. So when everybody else opens up their laptop at their desk, he could scooch over and go to the computer that's right there in the classroom. He just can't take it home, which was sort of like, nice try, school, but no cigar. The state education agency said that the reason the IEP team had said the student needed the software is because he needs it for longer writing assignments. Where do kids usually work on longer writing assignments? Usually at home. And the laptop that he took home didn't have the technology installed on it. Without this assistive technology on his laptop for home use, the kid was denied equal access. Now, do you see here how now we're mixing and matching the two standards, right? This is really an IEP complaint, but the State Department of Ed in Iowa grabs that equal access component of Section 504 and the ADA and says without the AT on his laptop for home use, he didn't have the same stuff to access at home that his non-disabled peers had when they took their laptops home. State Education Department found it to be a violation. I think that's dangerous, I think, when state agencies confuse those two standards. I think it's fair. I think they're probably right, but I don't like it when state departments of ed mix and match IDEA and 504 without making it clear that we've got two different statutes at work there. This California case is a fourth grader with some pretty significant language impairments. The team offered desktop computers that had voice output technology, so it would like read the screen to the student, both in the classroom and in the resource room. And they offered the student an AlphaSmart word processor for personal use. When you see AlphaSmart, I assume that y'all looked up and said, oh, it's a 2000 case. It's kind of old, because I think AlphaSmarts kind of have been, some schools are still using them, not a lot. A private consultant here said, you know, an AlphaSmart isn't as good as a laptop. This kid should be able to use stuff at home because the laptop at home and school both should have voice output capabilities. School said, no, we think the AlphaSmart is good enough. Mom filed for due process. This case makes me laugh a little bit. I'll show you why here in a second. The hearing officer said, really, up here, when the expert said laptops for use at home, really what the private consultant was saying is it would be more efficient for the girl to have the same device at home as she had at school, rather than identifying what she actually needed for education benefit. Here, there was no evidence that the kid's needs could only be accessed with the voice output. There were other technologies. And the reason I laugh is this is a case where the hearing officer said all she has to do to access the same technology at home, because mom had a voice output device at home, is put her stuff on a floppy disk, carry it home, put the floppy disk into the computer, and then the home computer that mom already had would read that voice output technology. The reason that makes me laugh is, truly, honestly, I have a 20-year-old and a 16-year-old. They don't know what a floppy disk is, right? So this is a case where school won by using sort of antiquated technology by our standards, but it was able to show that the students' educational needs were being met by that. It was less efficient, but it was enough to meet her needs. Now, my question is, given what we know now about ADA and Section 504, how they're currently being interpreted, I don't think that this efficiency argument thing would go with one of those claims because she did not have equal access. It was less efficient. That was going to win them the IDEA case in 2000. I don't think that would win them ADA case in 2016. Oh, yeah, so then I like this want but need analysis. I like that phrasing, and so there's another example about that. This is a more current case, and this is the case I was talking about with AT at home, then leaking over into the needs at school. So this is a nonverbal kindergartner with significant impairments on the autism spectrum. The school district met in February of his kindergarten year, and the student was actually making great progress. He met 11 of his 14 goals. At that meeting, the parent mentioned that the student had begun using an iPad at home for some basic communication and also for some self-regulation. They discussed it at school, but there was no formal assistive technology evaluation requested by the parents. The team then also did not initiate an assistive technology evaluation, I think because the team looked up at his goals being met and said, we're doing good. The IEP team didn't make any mention of an iPad or technology. Later on, a private AT evaluator said an iPod Touch is something that the kids should use, and the school then implemented that the following school year. Okay, so what we're really talking about is what happened from February of kindergarten year through the end of kindergarten year. The parents claimed that the failure to immediately begin an AT evaluation based on their comment at this February IEP meeting, that constituted a denial of FAPE. Okay? Now, this went all the way up to district court. Look at this. Mention of using iPad at home then triggered the school's obligation to consider use at school. Again, we need to train the people that are sitting in these IEP meetings to know that once mom and dad mention the kid using his phone, his iPod, the Wii, we got to start thinking about whether or not that is sufficient to trigger our obligation to consider use of the technology at school. And if you're considering it, you better document it. So here's a quote from the case. Prior to learning about the kid's success with the iPad in February, the district was reasonable to believe that the student was not ready to start using high-tech devices, as his knowledge regarding such communication was still emerging. But once it was mentioned, that triggered their obligation to consider it. So, we all think about home AT in terms of sending stuff from school home, but I also want you to think about in terms of stuff from home leaking into the school. They awarded this kid 20 additional assistive technology sessions as compensatory ed, and surprise, surprise, the private therapist that recommended the assistive technology is the one that got the money for those sessions. So here's my suggestions for considering assistive technology at home. Your team has to consider, is sending the stuff home necessary for FAPE? Now, I really, truly, I cannot tell you how crazy it makes me when schools condition parents taking home stuff that we've said kids need to receive education benefit on parents signing some sort of waiver, right? State law governs loss, theft, or damage, but you cannot condition educational services on parents' agreement to waive some kind of their rights under federal law. You can't charge for the normal wear and tear that's going to happen to an iPad or some other device from it going back and forth in the backpack to home. I also don't think we should rely on parental insurance. We have no way of knowing how good the parent's insurance is. Insurance for these devices is not that expensive, and I think the school should buy the best possible insurance that it can and use it. I don't like the waiver, not only because I think it's probably a violation of our obligations to provide free educational services, but I also ask, what are you going to do when the parents refuse to sign it, right? You've set yourself up with this huge conflict that you can't win because you've already written the AT at home into the IEP. And if your principals are really pushing back on this, I suggest that you ask them this. Do we make parents sign a waiver or provide proof of insurance before every kid takes his math book home? The answer is no. And so if we're not doing it for the math book, when the student takes her iPad home, we shouldn't make her mom and dad sign a waiver for that either. So that's just my little rant on what I see as just kind of some blatantly unlawful stuff that I see schools doing. So I don't think we should demand the parents sign a waiver or a release. I think it's foolish, and I think it's quite possibly unlawful. I do think you should have a district policy that addresses who can use that AT at home. So if if you send an iPad home, can Big Brother stream music on it? Can Sister use it to access Facebook? Are we going to let mom and dad put apps on the iPad? Are we going to let them modify it in some way? I think you should have a written policy that says who we're going to report problems and malfunctions to, so that mom and dad can't claim that they knew from home use that it didn't work for weeks and weeks and weeks and the school didn't do anything. I think you should have a process that tells the parents how to report problems. We're going to talk about, does the kid get to take it with them when they go on a basketball trip or some other kind of field trip? What are we going to do when the kid forgets the device at home? Are we going to have a substitute at school? Are we going to run it home and have the kid pick it up at home? So these are all things that I think you should talk about in policy. Okay, I'm looking at my time. I got to keep clicking. Implementation is another area where I see problems. This is one where the kid was supposed to have a laptop. They had the same laptop, but it didn't work. They fiddled around from all the way from August when school started through January 7th was when the kid finally got it back. So he went the whole first semester without having the computer, but the student was still expected to perform assignments and turn them in. The state education agency here, not surprisingly, issued a finding of noncompliance. They said that the school district was obligated to make sure that the software, not just that the kid had the laptop, but that he had all of the software that was necessary for him to benefit. I'm going to skip this one. It's good, but you guys can see it. Read the facts of this one. I'm going to go back and do this one real quick. This is a Detroit case where the IEP called for use of an FM transmitter, but the parent claimed that the school hadn't used it. And here, the logs of the audiologist said that they delivered the equipment, but there wasn't any written documentation showing that the staff had actually used it. The SEA issued a finding of noncompliance here. I really think you can use this to emphasize to your staff how important it is that they document when they're actually implementing whatever the technology is. Also here, there were multiple violations in this case. I don't think the school would have gotten tagged for not documenting if they had implemented everything else with fidelity, but yeah, I want to draw your attention to this case. This is a case, Students for the Deaf and Blind, where a teacher had a gazillion years of experience in teaching students with hearing impairments, and she said that the kid did not need to use the FM transmitter after he received cochlear implants. In fact, the teacher said using an FM transmitter under those circumstances would actually be harmful to the kid. But remember, if it's written into the IEP, you have to do it. The court said, while some deference should be given to teachers, the classroom teacher is required to implement the components, even the ones she doesn't agree with or care to implement. And I throw that language out there at you so that you can use that to threaten your staff and tell them, by God, I really mean that you have to use this stuff. I'm going to skip this one and this one. I think you can read these on your own and see kind of what the facts are. So here's my suggestions for best practices. Don't let your procurement process deny the kid's FAPE. You got to train up the student and the staff, upgrade as necessary, and then document your implementation. I see I've got a question, so let me look at this real quick. When should you consider a formal AT evaluation versus an informal evaluation is the question. Really, that's going to be driven off how complicated the student's needs are and how confident you are that you have everybody at the IEP team table to know about what the resources are. If you've got a really good team that includes like a technologist or somebody with knowledge about district technology, I'm very comfortable with an informal evaluation in almost any circumstance. If you have a student with super complex communication needs, like a nonverbal student, a student like this last kiddo with the cochlear implants, I think those are all indications that you might want to go with a more formalized AT evaluation. And remember, we don't have any standards for what a formal AT evaluation is, so you can get by with doing something called a formal AT evaluation without spending a ton of money. And if you've got kind of contentious parents, then I think a formal AT evaluation, like a separate freestanding document, is a good thing. But so like any good lawyer, what my answer to your question is, it depends, right? It depends on how good your team is. It depends on how significant the student's needs are. There aren't that many cases where the court has said an informal evaluation isn't good enough. And the cases are cases like that Montana case where it's just so cryingly obvious that there wasn't a sufficient consideration of the kid's needs that I don't know if it was formal versus informal, but adequate versus inadequate, really. All right, time-wise, we have 5 minutes left to talk about kids misusing technologies. So I'm going to let you read this cartoon. And then I'm going to skip a couple of these cases and go to this kid with visual impairment. Oh shoot, this is a good case. I'll do these two. So this is a high school student that actually was sexually harassing a teacher on Facebook. The teacher, it was so bad the teacher got a protection order. This was a school that all the kids, this student was a middle school student, and everybody in the middle school had an iPad one-to-one. So what the school did is they disabled internet access on the kid's iPad so that he couldn't use the school iPad to continue harassing the teacher. All the educational apps were accessible, but he couldn't just surf the web. The kid continued to harass the teacher using his home internet, and then the parents sued, claiming that the kid should be able to use his iPad like all other students, and not having internet access was a denial of FAPE, which makes me want to slap these parents, and I'm not that surprised the kid was struggling with social appropriateness. Hearing officer said the school wins. Kid was not deprived of any educational benefit. The IEP didn't say anything about him requiring to have internet access, and there was no demonstrated need for internet-based apps at home. So this is one where taking like a half measure to punish a kid for misusing a technology, like not giving them access to social stuff but continuing to have access to the educational apps, is a great strategy for a kid that is misusing technology. Great quote. I can understand why the parents are disappointed that the district wouldn't let their son have the same privileges. There's no evidence to say it results in a deprivation of FAPE. Okay, this Brailer case is the one that I think is like my guiding light for disciplining a kid who misuses technology. This is a visually impaired student, used Braille Light, and when the student asked for help in locating a file, a staff member got onto this computer type thing and found sexually explicit files. So this was a visually impaired student that was a typical teenager who was interested in sexual content, and so had uploaded sexually explicit stuff into the Braille reader and was able to then read this pornographic material in Braille instead of looking at pictures like other sighted teenagers might do. So here's what the school did. They said that the student was not allowed to use this Braille Light for the remainder of the quarter, which is consistent with the other kinds of consequences they gave kids that misused technology. They had a bunch of examples where kids had misused a computer and lost computer privileges. The student, of course, sues, saying, look, I need the Brailer for educational purposes. And here's where the school was smart. The school provided the kid with a Perkins Brailer, which is the old school Brailer. It's older and heavier, and it doesn't have all the bells and whistles, but it was able, the student was able to communicate and perform educational tasks with the Perkins Brailer. Parents filed an OCR complaint, which, you know, when I first read this, I thought, oh crap, OCR is involved, that means the school is going to lose, but that's not true. The school said this is similar to how the school responded to other misuse of school computers. They had already reinstated his access to the Braille Light when the complaint was filed, so it was for a short period of time, and they gave the student an effective means of receiving his services through the Perkins Brailer while he was being punished. So I think this is, obviously not every kid who misuses technology is visually impaired using Braille, but I think this is like a good guidance opinion to think about how you punish a student who misuses technology in a way that's sort of emotionally and functionally equivalent to how you punish a typically developing peer who misuses technology. I think you should have a clear district-wide acceptable use policy and make sure that your SPED staff has thought through how that's going to apply in your unique circumstances. If the student can comply with the acceptable use policy, I think you should say so in the IEP, so that when we get to manifestation, we're not fighting about whether or not the kid was actually able to follow the rules. If you're going to take a student's technology away as a punishment, remember that could be a change in placement that might require a manifestation determination. Don't be afraid of that, but just know that that step exists. If you're going to change a student's ability to access assistive technology due to repeated and consistent violations, like the student where they disabled the internet access, I think you probably should convene an IEP meeting so that you're not unilaterally changing the placement of a student. And then, just like with the Perkins Brailer, consider, is there some alternative technology that the student can use while he's being punished or deprived of the access? Remember the Fourth Amendment. Just because a student is using assistive technology doesn't mean they may not have a reasonable expectation of privacy. You want to make it clear to the student and to the parent that they should not expect the student's files to be private. That was one of the issues in that Braille case, whether or not the student reasonably expected that the files he put on his Braille light were private. And they had put into the acceptable use policy that nothing any student puts on a school computer is private, so the student was held not to have an expectation of privacy. Last thing is bring your own device issues. If you have parents are sending a technology from home to assist the student, how are you going to deal with the student misuse of that, particularly if the student needs it for school? This is why I don't love having assistive technology be purchased by family, even if their insurance will pay for it, because if we own it, we control it, and I think we're much better able to consequence it. Okay, time for questions, and I see that we have at least one. Okay, and it's long, so let me quick read this. All right. We've done situations where students use an alternative to high-tech devices to go home for communication purposes. A communication binder goes home, and the iPad is used at school to provide opportunities. They've had access to the same equipment at school in case there are high-tech failures. Is that a good practice, or do we have to match the high-tech to go home? No, you don't have to. It's all a question of what does the student need to receive meaningful education benefit. And if you've talked in an IEP context that the communication notebook is going to serve the same function and be an effective method of communication for the student, I think if you've had that conversation and the team has considered it, then you're almost unassailable if the family wants to challenge it, because you've actually had that effectiveness consideration in a formalized context. So that doesn't worry me at all. Now, if what you get is the kid consistently losing it, or it gets waterlogged, or pages rip out or fade, if there are any indications that the low-tech solution is not effective, then you may have to reconvene the IEP and consider the high-tech alternative. But if low-tech is working, I think you're perfectly fine to use the low-tech option. All right, it's 11:33. Gosh, I'm sorry that I went over, but there's so much information here that I wanted to get out to you. I hope you found this helpul. I really would encourage you to give Gail some feedback and let her know if there are things that I could have done differently or information that you want. I will give you my contact information if I can close this up. There we go. Here's my contact information. I'm not licensed to practice law in Texas, so I can't give you legal advice, but I'm more than happy to answer questions. I'll let you email me or text me or tweet me. If you've got questions in the next 24 hours or so, there's no additional charge for that. I just want to make sure that this was useful to you and you get your questions answered. So with all that, Gail, I will turn this back over to you.
Okay, thank you very much, and thank you, Karen, for very informative and good presentation. Again, to remind everyone that we've recorded it, we'll put a link, and the link will probably be on my Assistive Technology webpage. I'll send out notice to all those who attended today, and I'll also send out a notice to special ed directors in all of Region 10. And Karen, thank you very much for allowing us to record it.
Sure. Thanks so much for having me. I, really, like I say, I really support the work of intermediate education service agencies, so I'm delighted to have a chance to do this.
All right. Thanks so very much, and everybody have a good day. All right. Over and out.